Good morning, everyone. Hope everyone's well this morning. We'll get started when courtroom two joins us. Good morning, Mr. Dodd. Hope you're well today.
Doing all right, Judge. How are you, sir?
I'm doing well. Before we get started, Mr. Dodd, on the add-on calendar with Patricia Shelton, I put her on the calendar today. She was at the SEA calendar on Friday. And I asked the social worker to visit or have a social worker visit with her so that we can kind of figure out what we need to do
All right.
with her. So that's why I put her on the calendar for today, and I wanted to put her on my calendar so that we could kind of monitor her.
And Judge, I recognize, uh, I had spent about an hour and a half yesterday at the jail just waiting to see my first client, and I was really frustrated, to say the least. So there's been communication within our office. Our social workers, one of them is going to be here this morning. She's going to go out and speak to Ms. Shelton because I think she's still in the FOU section of the jail. And I'll provide an update sometime before SAP is over, Judge. We may obviously, we're probably going to reset it for the 30th, but I want to at least let the court know that we're working on it. And
Okay.
it is what it is, Judge.
Yeah, well, thank you. I just wanted to make sure that that she was seen as quickly as possible by a social worker, and that, if we can move her on, if we can put her back on another calendar if necessary, whatever the recommendations would be, that would be helpful. All right, let's see. Where would you all like to start this morning?
Judge, I believe, hold on, let me go to. Your Honor, that is position 16 through 18. Akita Cole, Judge. And Your Honor, I wanted to, I think I had emailed Mr. Rhodes, and I'm not sure if Ms. Evans' battle is on to this morning or not. But the dates for credits are off in many of the recommendations. And as far as Mr. Cole, the reason I'm bringing this up is on specific on Mr. Cole, I believe it's a time served sentence because the total amount of days that he spent is beyond, I think he had spent 40 days, and the recommendation is 60 days. With 2 for 1, it should be time served. But if you look at the recommendation, it appears that he has more jail time to do. I just wanted to kind of clear that up. As far as specifically Mr. Cole, and I think several other cases are likewise similar situated.
Yeah, as it relates to the recommendation that I gave for the time, it was the recommendation. I didn't really calculate the jail time. That's something that I leave up to the Fulton County Sheriff's Office. So if it's
Okay.
time,
Well, and I appreciate that. Good morning, Mr. Rhodes.
Morning.
And I know that that you don't normally do this calendar, that it's Falk's. What Ms. Falk normally does is that on our calendars, she will have the time served, let's say 30 days credit for time served, 15 days balance probated, something of that nature. So we know if it's a time served, if it's time served plea, if that's what the state had meant to do. So we'll just have to work through them the best we can this morning as far as what the recommendations are, but I am going to need for to know what time has been served on each case, regardless of whether it's a time served case or not. So just know that when we get to a case that I'm going to need to know the time served.
is there someone here from the Sheriff's Office that can provide that?
Judge, I can at least inform the court as an officer for the number of days that I came up with, and I think I can break down the days, but
Yes.
obviously I'm not the custodian of the jail records, but I looked those up specifically.
Good morning, Mr. Rose. The sheriff does not provide that during court. The SG does, and then if it's.
Don't calculate. I just want, I understand that what Ms. Falk was doing, and I can appreciate that, but we're not the custodian of those records. We don't calculate jail time. That's something that the Sheriff's Office should be doing if they're not.
Okay, I'm just saying, Mr. Rhodes, how we have normally done it is that Ms. Falk will say, and she will be very specific. She will say credit for time served from this date to that date and from this date to that date. So if you look back at the calendars for previous, that's what she does, and she likes to put it on the record. So she's getting those dates from somewhere prior to this calendar. And maybe
She's getting it from the gelling screen, Your Honor.
okay, well, wherever, that's how we normally do it in this court. So if it's something that's going to be different today, I understand that, but it just throws everybody off when we're used to doing it one way, and we don't follow that procedure. So however we can get that calculated today, that may take us a little bit longer, but we're going to need to know from somebody the jail time. Mr. Sirocco, are you here with me?
I am, Judge. And
Okay.
while we're presenting Deputy Rhodes' half of the calendar, I can be looking up jailing time
Okay.
and getting that for the court.
So you are you've been doing this calendar with us, Mr. Sirocco, and that's the way we normally do it, correct?
Yeah, that is correct, Judge.
Okay, just wanted to make sure. Okay, so
Judge
let's go
Mark,
ahead.
excuse me,
Yes,
before
Ms.
we
Young.
start, Miss Lucia is on. I called her and I emailed her. We don't need her this morning because the client waived. That was
Okay.
the add-on position 2. Arena Reyes Jefferson.
Thank you, Ms. Young. Ms. Lucia, you on with me?
Good morning, Your Honor. Yes.
Good morning. Thank you for being here this morning. Apparently, we're not going to require your services this morning, but I certainly do appreciate you jumping on for us.
Yes, Your Honor. You have a great day.
You do the same. I'll see you next time. Thank you.
Bye.
Okay, so, and this is Mr. Cole here.
It is, Judge.
Okay, do you all want to get started or?
Your Honor,
What do
I'm ready. What I had communicated to my client is he had spent, I mean, I believe more than 30 days. So, I mean, it's a time, my request is it's a time served, it should be a time served sentence, Judge. Now, whether that's a hang up, I don't know, but it's.
Okay. So what I'm going to want to do is just go through each, because I don't have a recommendation on my calendar for position 16. So I guess what I want to do is go take them position by position and just see if we can work it out.
Judge, could I get, so is this position 16 you said? This is.
16, 17, and 18.
Okay.
And Judge, I think while Mr. Oh, who else do we have here?
And
Houston.
in this, Mr. Rocco, you could do that. I must have left the as it relates to position 16 off, but I know that it's concurrent with 15 and 17. So it would be no more than the 60 days that that I recommended for positions 15 and 17, because all of those are concurrent sentences. So
sorry.
the black recommendation would be 12P, serve 60 days balance probated.
And Judge, while we look that up, we can handle position number 24, Corey Houston. That's more straightforward, Judge. That's one case, and we can deal with that, Judge.
Okay, so that's fine with me. So we'll come back to Mr. Cole.
I apologize, Mr. Houston. Have actually two separate substantive cases. But we can start with those, Judge, and then I can, in the meantime, we can address, I think it's a little bit more straightforward with these two cases, Judge.
Okay. Good morning, Mr. Houston. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Say it again for me. Still can't hear you.
Yes.
Okay, very good. Thank you. You can place your hand down, Mr. Houston. Yes, Mr. Rhodes.
Yes, the state recommendation is 12 months to serve 60 days, balance on probation, that he receives behavioral health and evaluation and treatment, have a social work visit, stay away from 1295 Donnelly Avenue, Southwest, Atlanta, Georgia, and no further contact with Ivory Patterson. The restitution in this case is $500. As it relates to count 2, the criminal trespass, we're asking for 12 months probation, credit for time already served, obviously, concurrent with count 1.
Mr. Dodd?
Your Honor, we stipulate for purposes of the plea, as far as venue, identity, and factual basis. Judge, as far as position number 24, he's been in custody since September 9th. That means he has credit for 15 days. Position number 27, Judge, he initially was arrested July 2nd, spent 4 days, and then the 15 days since he's been in custody. So a total credit on the first case, 15 days. On the second one is 19 days. Either way, Judge, he has a little bit more time left to spend in custody. I would ask the court to consider waiving the first 2 months of probation fees or placing him on non-report upon completion of all the conditions. I did want to point out to the court, he does have a hold from the cab, so he's not going to be released right away anyway after Fulton County, Judge.
Okay, so you said 15 and 19?
That's correct, Judge.
Well, that makes 34, and the state is
Yeah.
asking for 60.
I'm sorry, Judge. What I meant is on the first case, he has 15 days. On the second case, he has 19 days. Because the second case, he was arrested in July, spent 4 days, bonded out, and then there was an FDA. So
And when you say the second case, you mean position 25?
position number 27, Judge.
Oh, okay, I'm sorry.
I apologize. So position 24, he's entitled.
Well, we haven't heard about position 27 as of yet.
Judge,
You didn't mention 27, did you, Mr. Rhodes?
I did not. I can give the recommendation for those because as it relates to 27, all I'm doing is running them concurrent. So for example, 27, count 1, 12 months probation credit for time served. And I'm running it concurrent with case number 25 CR 005-461H, which is position number 24. Count 2, the simple battery, 12 months probation credit for time served, concurrent with count 1 in this particular case, and no further violent contact with Officer Nasir Muhammad with the MARTA Police, and to run concurrent with 25 CR 005-461H. In count 3, the willful obstruction, 12 months probation, credit for time served, concurrence with count 1 and 2 in this accusation, as well as to run concurrent with 25 CR 005-461H. So all the matters to run concurrent, Your Honor, with the global being 12 months served, 60 days, balanced, probated, behavioral health evaluation and treatments, social work visit, stay away from 1295 Donnelly Avenue, Southwest Atlanta, Georgia, no further contact with Ivory Patterson, and no further violent contact with Officer Nasir Muhammad with the MARTA Police. And of course, 25 and 26 will be null pros.
Yeah, Ms. Young, as far as the paperwork goes, and
Yeah, so it's really, position 24 is 30 days, it's 2 for 1. And on position 27 is 28 days. Because he's been in for 15 for position 24.
regardless, they're asking for 60.
Yes, but I'm trying to write the days down, or I could put credit for time served. So are we gonna do the 30, because we do 2 for 1? They asked for 60, but I usually write a date down there since they've been in jail. So I wanna know how to move forward. So do you want me to put arrest date since 9/9, but we usually put days and not the date? So how would you like for me to move forward, Judge Mara?
I want you to do it how we normally do it, however we're gonna accomplish that this morning. So if they're asking,
Time served, it'd be 30 days on 24.
okay, it's not a time served plea though. It's what
No,
I'm saying.
Credit for time served.
Okay, and the credit is how much?
It would be 30, because he's been in 15.
It would be 15, and then he gets the 2 for 1
Yes,
for position 24, and then
30 days.
on the other position 27, it would be 4 days he would get credit for. So 2 for
So
1
they
would be
said not, but, so it's not 19 days?
19 days between the two cases, but it's 15 days on that on 24, and
He has credit for 8 days, Your Honor.
yep.
I mean,
Morning, Mr. Jordan.
So if he's only been in for 15 days, and if you do to serve 60 days, that means the jail is expecting him to do a total of 30 days. So he would have 15 more days to do in jail, and it's not a time served plea.
Right.
That's right.
So it was my understanding that everyone knows that it's not a time served plea. Is that
Oh.
right, Mr. Haddad?
that's right, Judge. And normally on the plea sheet that I submit, what I would write is 60 days with credit for 15. Because the sheriff's office then they don't have to, but normally they will treat the 60 as 2 for 1. So that's how I would write it, is 60 days with credit for 15.
So he's still gonna have to do 15 days.
That's correct. So if I put credit for time served, if I put 12 months, served 60 days, credit for time served 30 days, he would have 15 more days.
No, so your time served should still be 15 days.
It should still be 15. Even he gets the 2 for 1, but they would say 15 credit for time served 15 days.
That's fine. Okay. Thank you all.
Okay. So is that clear for everyone? Mr. Haddad?
Yes, Judge. I mean, he's That is correct. He's not getting a time served sentence. My calculation, he has another 15 more days in custody, Judge.
Okay. And Ms. Young, as far as the paperwork goes, for both the charges, we've got that settled? Ms. Yu-
I'm sorry, Your Honor. Yes, sir, I have the correct now, Your Honor.
Okay, I just want to make sure everybody's on the same page. All right, if nothing further, Mr. Houston, it's my understanding that in case 25 CR 0054618, you wish to plead guilty to criminal trespass and damage to property and criminal trespass. And in case 25 CR 0037878, you wish to plead guilty to fair evasion, simple battery, and willful obstruction of law enforcement officers. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
Oh.
You've been represented by counsel. Are you satisfied with his representation? Say it again for me.
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Houston. When you complete the terms of the probation, I'll have it go to a non-reporting status. I will waive 2 months of the probation fees to help you get on your feet. Good luck to you, sir. Okay, where can we go next?
Yes, you got it. Your Honor, we can go to South Annex. I believe that's positions 33 and 34.
Okay, thank you. Mr. Murphy, good morning.
Good morning, Judge. I've got Labarise Hayes. I don't know if he was brought over. That was something from last week. Did you reset a week out due to the bond?
Oh, Murphy, is this your client, Billy Lowe?
No, that is not.
Okay, let's see.
Judge, I recall I think he was McLeod's.
When is Miss McLeod going to return from holiday? Do we know?
I thought Judge it was tomorrow. On Wednesday.
All right, given that
Thursday.
she's,
I can put him on Thursday, Your Honor.
yes, let's put him on Thursday. I don't want him staying in custody so that she can handle him on Thursday.
Yes, ma'am.
Mr.
yes,
Lowe,
ma'am. Sorry, yes, ma'am.
Mr. Lowe, your counsel is not with us today. She will be back by Thursday. I'm going to reset you for Thursday so that you can discuss this matter with her and we'll move it forward at that time. Okay, so we'll see you back on Thursday, sir.
Yes, you are.
All right, have a good rest of your day, sir.
Yes.
And Your Honor, if we can go back on position number 16 through 18, Mr. Cole, Judge. I was looking at the wrong defendant. On Mr. Cole, our contention is entitled to 28 days. The recommendation is 60. So that means he has 2 additional days, Judge. But other than that, we are ready to proceed.
And Judge, yeah,
Go
on
ahead.
that, okay. So for Mr. Cole, the credit for time served that he would receive is for 19 days. I see that it's from September 5th of this year to present. And then I don't see credit for time served in jailing for either position 16 or 17 for him. So all he would be entitled to is the 19 days on position 18.
Judge, Mr. Cole has been in custody since August 27th. He wasn't transported until Fulton County until the 5th, but he's been in custody since the 27th of August.
That would have been from what I can tell, would be other charges. There's a felony criminal trespass, damage to property. There's a foreign county hold. And yeah, oh, excuse me, hang on. That was for the previous case. You said he's been in custody since when?
Since the date of offense, for the shoplifting, August 27th.
Yeah, I don't have any of that in here. So from the state's perspective, he would not.
Well, the state's perspective is that he's been in custody. You were in East Point? Were you in East Point?
Oh, yeah, East Point.
He was in East Point, so, he was there 9 days before his transported to Phelan County, so. We can cut it either way, he's still entitled to that time.
What we have record of is 9/5/2025 to present.
Well, might as well just plead everybody not guilty and move on. And this is,
So Mr. Dodd, with your calculations, how much time would he have to remain in custody?
Yana, on position number the last position, which is, it's 28 days is what he's entitled to. So he would have 2 additional days on that case. The other 2, position 16 and 17, Judge, I don't dispute the state's contention, because I don't think there's failures to appeal on those 2 cases. I guess really what it boils down to, I'm gonna have to ask a non-negotiator on those 2 cases to ask for just straight probation on those 2 cases. Because the state is correct on position 16 and 17, whatever time he initially served, that's all he's entitled to by law. So I think he spent like 2 or 3 days on each case, perhaps. Whatever Mr. Sirocco pulled up is accurate. Because this time around, he's only been in custody on the latest charge, which is I believe he's entitled to 28 days. And I guess if we need to do a non-negotiated plea on those 2, the first 2, I'm asking for straight probation, instead of, more time, much more time.
Given that he, regardless, is going to have to, and this is up to you, Mr. Dodd. If you want to reset him, given that he has to get this all worked out till next Tuesday, given that it's not a time served plea, I'm happy to do that. Because regardless, we're going to have to get the numbers together for the paperwork. And
That's fine. That's
would
fine.
that be acceptable, Mr. Dodd?
Yeah, that's fine, Judge. We'll reset it for next Tuesday.
Okay,
We'll,
so that we can work all that out before that time.
sounds good, Judge. Thank you.
All right, I'll see you back next Tuesday, Mr. Cole.
All right.
Mr. Murphy, are you still on with me?
Houston Johnson,
Yeah. Judge.
I'm sorry, can you give me your announcement again and tell me who the person is?
This was LaBarice Hayes that we were on last week, and you agreed to reset it a week out due to the determination for the bond.
And what are we gonna do with Mr. Hayes?
Judge, at this point, I'm just arguing if we can readdress the bond issue. Right now, you have all the charges as cash bond. He's unable to make that.
Okay,
It's
who's gonna handle Mr. Hayes this morning?
What position is that, Your Honor?
It's positions 20 through 22.
Yeah, those are my cases, Your Honor. As it relates to position number 20, and that's 25 CR 002-337C, the recommendation.
Hold on, I'm sorry, Mr. Rhodes, I don't mean to
I'm
cut you
sorry.
off. It's only a bond modification hearing.
Okay.
Mr. Murphy's asking for a bond modification, so let me, I'm gonna need to know if I set these bonds, and I have to refresh my recollection. Ms. Washington, can you give me the history for Mr. Hayes?
Yes, sir. Just give me one moment.
Thank you. Good morning, Ms. Washington.
There are 3 arrest cycles out of Tennessee. None that list any battery family violence. There are 42 arrest cycles out of Georgia. There was a 2021 felony conviction for aggravated assault out of Clayton County. There was also a 2015 simple battery, possession of cocaine, possession of meth, possession of marijuana less than an ounce out of Clayton County. And that is all that I see in the last 10 years, Your Honor.
Thank you. Yes, Mr. Rhodes.
Yes, Your Honor. As it relates to the bond, we do believe that the bond that was set, in fact, reasonable under the circumstances. The defendant, in addition to the criminal history that you just heard from pretrial services, has a total of 3 cases on this calendar, all involving battery family violence. In addition to them being violent in nature, they also involve the same victim, whose name is Miss Regina Mason, where this defendant has terrorized this victim in each one of these cases, causing not just terror, but also physical harm to her as well. So we'd ask that the bond remain as is. We do believe that the bond is reasonable, that was already set by this court. Thank you, Your Honor.
Okay, who set that bond and how much did I set it for, or the judge set it for?
Judge, you set it for 2,000 cash on the first count, 1,000 cash on the second, 1,000 cash on the third count.
Is that position 22 that you're talking about?
That would be the case ending in 589C.
And what about the other 2 cases?
Judge, I thought that he,
So we don't need to address
Yeah.
bond modification for 20 and 21? Say it again?
I thought we were only addressing that case. I thought that he had that there had been bond already set, or he already made bond on those other cases.
Okay, that's fine. Anything further? Mr. Murphy?
No, Your Honor. I do believe that the previous bond orders had a stipulation that he stay away from that victim, as well as that address of 1006 Sim Street, Southwest Atlanta, Georgia. And in each one of these, that bond condition was violated. And I do believe that if we have not, we will likely, in the divisions of court that they're in, file the motions to revoke bond. We just feel that the bond is reasonable.
Judge, my client had stated in open court that he was not present for that. As it pertains in this particular case, the alleged incident is on June 16th of this year. And then 9 days later, a warrant is issued. It doesn't appear that anyone made any determination at the time of the incident, despite it being claimed to be so heinous. My client is gainfully employed as an auto mechanic, ASE certified for 17 years. He has always maintained his innocence. He says he was not present there. His fiance says that they were out of state on that particular day, and they remain puzzled as to why these charges came up, and they've always my client contends that this is all contrived out of some sort of sort of other issues with the alleged victim. And I believe,
refresh my recollection, Mr. Murphy. I believe that we had Miss Mason on the line at one point in time, and she was attempting to recant this specific charge, which is why I wanted, I believe, and tell me if I'm confusing this case with another case, but I believed I asked the solicitor's office to make sure that by this hearing, they spoke with her so that they could verify what she needed to tell them. Has anyone from the solicitor's office spoken with Ms. Mason in this regard?
And that may have happened, Your Honor. I'm having technical difficulties. I'm having the team come in now so that I can have internet access. I'm going to ask Mr. Sirocco if you'll look at the victim tab to see if that has in fact happened so that we can provide that to the judge.
Sure, let me look really quick.
And-
Could I get if someone could just read me the case number, that would be
I'll get it for you. It's 25 CR 005 589C. And I'm having internet difficulties, so I.
Your Honor, while Mr. Sirocco is looking at position 20 and 21 is time served. He's done with those two cases. He only has this one open case, 5589.
let's see.
Judge, and my apologies, I've been ill the last couple of days. I wasn't able to circle the wagons on this and reach out to the state.
Could I get if the court could reiterate its inquiry that I can look into one more time?
Last that this was on the calendar, it's my recollection that the alleged victim, Ms. Mason, was on the line. Ms. Falk, I believe, was here also, and she was attempting to recant. At that time, I asked to place this on this calendar so that the state, through your victim advocate, possibly could reach out to her so that you all could verify what she was telling the court so that I could make a proper determination on this bond modification. So I need to know if somebody reached out to Ms. Mason and if you all made a determination.
So what we reached out to Ms. Mason, and with respect not to what the court was looking into here, but we did speak to her about the state's plea recommendation, which the victim states she is in agreement with. She does request no further violent contact so that the defendant can assist with co-parenting. There's a 10-week-old child they share, and she states they are no longer in a relationship together, excuse me. So that's the information I have with respect to subsequent victim contact. And
okay, well, Ms. Mason is here on the line, so let me see if she wants to say something or if you all want to talk to her. But I'm going to listen to what she has to tell me. She was on the line, I believe, the last time as well. But Ms. Mason, are you with me? Or would you like to address this matter?
Hey, good morning, Your Honor.
Yes,
I'm
ma'am.
sorry. I'm in the middle of breastfeeding. I'm sorry, my baby acting up right now. But we have a 10-day-old baby. And
Okay.
some kind of way, I don't know if it's in the computers or what, but this is the same case where they had gave him a bond where he's supposed to be out on bond. Rather, these two incidents happened on at the same time. I don't know how the warrants were filed separately.
Okay, I think we're talking about, he had 3 cases. This is a 3rd case.
It never should have been a third case. That's what I was saying. It shouldn't have been separated. We already supposed to have that understood for this case that y'all bringing forth now, saying that it's new. I thought we already had amended it when we went to court last time.
All
So
right.
I don't know if the warrant was filed late or.
Hold on, Ms. Mason.
Yes,
Mr.
sir.
Rhodes, you all are going to have to reach out to Ms. Mason and figure this all out at
Yes.
some point. That was my request the last time we were here, because that's and because this is the same confusion that we were having at that last hearing date. And at the same time, Ms. Mason was having difficulty with her child as well, which is why I believe that I wanted you all to reach out to her. And
okay, can I clarify from the
And
warrant to
I
this?
can have a social worker do that as well. I'm sorry, Mr. Sirocco.
Yeah, if I could just clarify from the incident reports we have here, if the court or the state would be so kind as to read me the dates of there's 3 cases before us here.
Yes, the one that we're addressing on bond is 25 CR 0055589C. It has an offense date of 6/16/25. There is
Okay.
also case 25 CR 0023338C, and it has an offense date of February 15th of 2025.
Mhm.
And then we also have 25 CR 0023337C that has an offense date of January 21st of 2025.
Yep.
And
So I have multiple warrants from each of these different dates. With January 1st was striking in the face several times, causing small cuts. And that warrant is dated February 4th, but on the probable cause, it states that specifically this was January 21st of 2025. That was the incident date. And then on the second case referenced, that one has an incident date of February 15th, and that was striking her clenched fist, causing swelling. So different injuries, different incident dates. And then with the June 17th incident, this was Miss Mason stated that at 1600 hours on June 16th, 2025, the defendant broke in through the back window of her home, and excuse me, he did other things, but I will mention he became violent. That is when the altercation began. She suffered a busted nose, with blood, a busted lip, bruises on her inner thighs. These are 3 different incidents. There should be no confusion here. So I'm not sure what the makeup is.
The confusion was that Ms. Mason said that never happened. And that it was, and so my inquiry the last time was for someone in the solicitor's office to follow up with her, so you all could determine, what's what.
yeah. So, Your Honor, we get victims that recant all the time in these cases.
I understand that, but this was a specific instance where we had a specific reason that where he was, and this was something was not normal in the normal course, which is why I asked someone to follow up. Now, this man has been sitting in jail for however long since the last time that we were here, and I understand,
Your Honor, if it would give the court some comfort here that we could reset it to Thursday.
I'm not
and in the
gonna reset it. She's here now.
Well,
and
Your
she
Honor,
was here.
respectfully, we're not going to take her at her word with this being the 3rd violent case. We can look at the
Well,
evidence. we can speak-
And what I can tell you,
asked
and what
you
I
to do
can tell
this
the court is that
before.
Ms. Donyetta Calloway from our
Give me a
office.
moment.
Okay. I just want to tell you about our attempts at contact, because we have made contact.
Okay, tell me what you need to tell me.
Yes, Your Honor. As it relates to victim contact, I do have internet service now. As it relates to this particular victim, our victim advocate did reach out to the victim on September 15th. Donyetta Calloway is the victim advocate. She emailed her and as well as called her and left a voice message and got no return call. She had an unsuccessful attempt on that date. She did leave a voice message. And from my understanding, that there was contact made on yesterday, September 22nd. And the victim is requesting no further violent contact with the defendant. And because she would like for him to assist with co-parenting the 10-week-old child that they share together. Yes, but Your Honor, as Mr. Sirocco was indicating, is that when we see this many cases and this many acts of violence, very hard for us to take her at her word. We know that these are 3 separate incident dates. We do know that sometimes we have to protect victims from themselves when they are in a cycle of violence. And what we do know is that Mr. Hayes has a lengthy criminal history. Probable cause was established at the day that this warrant was taken out. If there's an issue as it relates to an alibi in terms of where he was, that's a defense for trial. We're not at that point at this particular moment. Now, of course, Your Honor can do whatever you feel fit for, you see fit for bond. But, I do think the issue of alibi is premature. We believe that all three of these incidences did take place on the incident dates, and given his criminal history, as well as the 3 cases he has with this one victim that he has terrorized, we do believe that Your Honor was correct in setting the bond that was set. And we did, in fact, file the motions to revoke bond in the other 2 cases.
Murphy?
Judge, unable to make that bond. We're here on misdemeanors, Judge. I'd ask for a reasonable bond, Judge. Again, he's employed. He's within the community. He has no reason to be around this person whatsoever. He can certainly retain counsel as to visitation and whatnot, but I've advised him to have no further contact until these cases are resolved. And again, he can file a legitimation petition if he wants to seek some sort of interaction with the child. And again, I think reasonable bond would be just a surety bond, and he's for the exact amounts. And if Your Honor wants some other stipulations, anger management, or just limit him to just employment and maybe going to see a doctor, or have it at. Again, I just think a reasonable bond. He's unable to make that bond. He does not have those type of assets to acquire $4,000 in cash.
Morrow, I would like to make a quick announcement. I know I said that those 2 cases was time served because that's what it says in the jailing screen, but we getting that straightened out.
They are open, and we filed motion to revoke bonds in those based on the 3rd offense.
Well, I got that part. I'm telling the judge what it says in the jail screen. So he did make bond through Atlantic Bonding Company, but for some reason, the jail put time served on those 2 cases over in the jail screen, but we see they are open on the case manager screen. So Mr. Jordan is getting those straightened out on the jail screen because they scanned somebody else's bond order up under his paper, up under his screen. And so he did make bond on those 2 cases. So I just want to correct my announcement.
Thank you, Ms. Young.
You're welcome.
Okay, Mr. Murphy, if you'll take this down. For the battery, it will be a $3,000 good bond. For each of the other charges will be a $1,000 good bond. Makes for a total of a $5,000 good bond. No further contact with Ms. Mason. That Mr. Hayes and Ms. Mason, you're listening to me, that means no contact whatsoever. No phone contact, no internet contact, no social media contact, absolutely no contact whatsoever. If I find out that there's been contact, the bond will be revoked. Stay away from her residential address. I want you to start the Family Violence Intervention Program within a month of being released. No drugs, alcohol, weapons while out on bond.
I've noted that, Judge, and I'll relay that to the family. We'll be all on the same page. We appreciate the grace of the court. Thank you, Your Honor.
You're welcome, Mr. Murphy. Good luck to you
Your
all.
Honor,
Ms. Young?
do you want him set for 2 weeks just in case he can't make the bond?
Again, in an abundance of caution, that'll be fine.
Okay,
Thank you, Ms. Young.
you're welcome.
Okay, who do we have next?
Good morning, Judge Morrow.
Good morning, Francois. I hope you're well.
Thank you. Hope you are as well. I do have a quick announcement for Mr. Dennis Murphy. I noticed he just signed out. I do need his service to into position number 4. It's RCRE. But I'll try to give him a call.
Okay. Thank you. And do we know if this is a time served plea or not for position 4?
Yes, Judge, she wants to take a plea.
I'll
My
get the
question is if,
jailing info, Judge.
my
If you
question
could,
is, okay,
yeah,
if
we
it's,
could
if
just
it's not
proceed
a,
with the
just
recommendation, I'll get
let me
that.
finish, let me
Yeah.
finish up with what I was saying. If it's not a time served plea, I want to reset it so that Ms. McLeod can handle it. If it is a time served plea, then I'll reach out to Mr. Murphy so that we can move it forward. Given our calendar today, I need to, we'll need to reset some of these matters. So if someone can tell me if it will be a time served, please, I'll know how to proceed.
Yes, Judge, I'm gonna
Okay.
call Ms. Dennis Murphy, and she does want to take a plea.
All right, who do we have next?
Next is position 42, Mr. Singh.
Mr. Dodd?
Judge, I believe that's Miss Tucker's. I'm trying to see if she's online.
Oh.
Yeah, she should be on Zoom.
Oh, there you go. Sit right there. Sit right there.
She's on. She's on.
Okay.
Yes, good morning, Ms. Tucker. What are we doing with Mr. Singh today?
It'll be a negotiated plea, Your Honor.
Okay. Good morning, Mr. Singh. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I approve.
Thank you, sir. You can place your hand down. Yes, Mr. Soroka.
Thank you, Your Honor. This was for the 2 counts of battery. The state's recommendation on count 1 is 12 months served, 90 days, credit for time served, 15 days. That is from September 9th of this year to present. Balance probated, 12-week anger management, no further contact with Bria Brown. Stay away from Grady Hospital at 80 Jesse Hill Jr. Drive in Atlanta, absent a bona fide medical emergency. And count 2, the other battery would be 12 months probation concurrent with count 1. No further contact with Carol Bigelow. We asked defense stipulate the factual basis, venue, and ID for purposes of the plea. And at this time, we would sound for Miss Brown and Carol Bigelow as well. We did speak with Bigelow, who advised they were okay with the recommendations here. And we didn't hear from Brown, but in any case, if we could sound for both.
Thank you. If either of those individuals are on the line and wish to address the court, now is your opportunity. Does not appear so. Ms. Tucker?
We do so stipulate for the purpose of the plea, Your Honor, and I would like to make a request to the court. Mr. Singh is currently unemployed and homeless. He's been waiting to receive Social Security, so we are asking that the probation fees be waived, and once he completes the anger management, that he be allowed to go on non-reporting status.
Mr. Singh, it's my understanding that in case 25 CR 005468H, you wish to plead guilty to 2 counts of battery. Is that correct? Say it again for me, sir.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
I know. Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
And listen to my question. Listen to my question, Mr. Singh. Did anybody force you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiable, sir. I'm going to waive the probation fees while you're on probation. And when you complete the terms, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, sir.
You're welcome.
You can go to position 45, Mr. Tripp.
Also a negotiated plea?
Yes, Your Honor.
Yes, good morning, Mr. Tripp. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, thank you. Mr. Sirocco?
Thank you, Your Honor. For the criminal trespass, state's recommendation is 12 months, served 28 days. Credit for time served 14 days. That is from September 10th of this year to present. Balance probated, behavioral health evaluation, and any recommended treatment. 20 hours community service, and stay away from 300 Prior Street, Southwest Atlanta. We ask defense stipulate the factual basis, venue, and ID for purposes of the plea.
We do so stipulate for the purpose of the plea. And Your Honor, we will request that after the community service is complete, that probation go termination or non-reporting.
We would be fine with non-reporting, Judge.
Okay. Mr. Tripp, it's my understanding that in case 25 CR 005469B, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Tripp. When you complete the terms, I'll have it go to a non-reporting status. Good luck to you, sir.
Next is position 46, Mr. Walker.
Also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Walker. Will you raise your right hand for me, please, sir? Thank you. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can place your hand down. Mr. Sirocco?
Yes, Your Honor. The state's recommendation for the theft by receiving here is 12 months, served 34 days. Credit for time served 17 days. That is balance probated. The credit for time would be from September 7th of this year to present. While on probation, anti-theft course, no further contact with Joya Burson. Stay away from 30 Weatherby Street, Southeast Atlanta, and 40 hours community service. We have spoken with Miss Burson. She is in agreement with the state's recommendation. I believe she said she'd be on, and if we could sound for her when appropriate. But in any case, we would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea.
This person is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Ms. Tucker?
We do so stipulate, Your Honor, and we will request that upon completing the terms of probation, that he be allowed to go on non-reporting status.
Mr. Walker, it's my understanding in case 25 CR 005368H, you wish to plead guilty to theft by receiving stolen property. Is that correct?
I do.
Are you under the influence of any drugs or alcohol this morning?
No, Judge.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Walker. When you complete the terms, it'll go to a non-reporting status. Good luck to you, sir.
Thank you.
Next is position 13, Mr. Caesar.
Also a negotiated plea.
It is, Judge.
Good morning, Mr. Caesar. Can you raise your right hand for me, please, sir?
Good morning.
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you, sir. You can place your hand down. Mr. Rhodes?
Yes, Your Honor. The state's recommendation is 12 months probation, 12-hour anger management, stay away from 165 Ivan Allen Boulevard, Jr. in Atlanta, Georgia, and that he pay restitution in the amount of $500 to the Salem Bible Church.
Mr. Dodd?
Judge, we stipulate, for purpose of the plea, I would ask the court to, place my client on non-reporting probation upon completion of the conditions and possibly waive the first 2 months of probation fees, Judge.
Does he have a place to live?
Your Honor, he does not. We're gonna provide him with information this morning. He did mention to me that he's got something worked out, but just as a backup plan, we're gonna provide him with additional information as well this morning, Judge.
Okay, Ms. Young, do you need any further information for the paperwork?
Is he giving him any credit for time served?
He's entitled to the time he's been in jail, so.
And I could provide that. You would receive 25 days credit for time served. That is from August 30th to present.
All right, so for the paperwork, 12 months to
Oh,
serve.
excuse me, that is incorrect. That is for a different charge. So please scratch that.
Okay,
My
In
bad.
any case, 12 months probationary sentence, so.
Mr. Haddad, your calculation is what?
5 days, Judge, from August 29th until today, Judge.
So I'm gonna give him 12 months to serve 5 days, credit for time served 5 days, balance probated with the rest of the conditions. Is that agreeable to everyone?
That works, Judge. Thank you.
Mr. Caesar, it's my understanding that in case 25 CR 005651A, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Caesar. I'm going to waive 2 months of the probation fees to help you get on your feet and try to find yourself a place to reside. Once you complete the terms, I'll have it go to a non-reporting status, okay? Good luck to you, sir.
Much appreciated.
You're welcome.
Your Honor, I do have a question. 12 hours of anger management, is it days or 1 day or?
Usually 1 day is 1 hour, so you can put days or hour.
So 12 days of anger management?
Is that how we normally do it, Ms. Young?
Yes, Your Honor, because that's what the
Okay.
statute says. Thank you.
All
Usually
right.
12 weeks, right? Isn't that the
It's
format?
12 weeks, but we just circle days because you only take it once a week. Thank you, Mr. Soroka.
Okay. Who do we have next?
Position 14, Mr. Campbell.
And Your Honor, this is gonna be a negotiated plea, Judge. The credit, and Mr. Soroka can double check, but he's been in custody. He's entitled to 29 days of credit. So based on my calculation, he has an extra day too. He should be released. The booking screen has him booked at Fulton County Jail on the 26th of August. And the handy calculator that comes with the Odyssey calculates at 29 days as of today, Judge.
Okay.
That is what I have.
Thank you. Good morning, Mr. Campbell. If you'll raise your right hand for me, please, sir. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Was that a yes? I'm sorry.
He said yes.
Okay, you can place your hand down. Thank you, sir. Mr. Rhodes?
Yes, as it relates to count 1, 12 months to serve 60 days, the balance on probation. We'd ask for a behavioral health evaluation and treatment and social work visit. We ask that he stay away from MARTA for a period of 180 days. On count 2, the criminal trespass, we'd ask for the exact same sentence to run concurrent with count 1. Thank you.
Haddad?
We stipulate for personal plea, Judge. I would ask the court to consider waiving the first 2 months of probation fees, Judge.
Does he have a place to reside?
He does, Judge.
Mr. Campbell, it's my understanding that in case 25 CR 005456D, you wish to plead guilty to criminal trespass and one other misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with his representation? Say it again for me. Still can't hear you.
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Mr. Campbell, I will have the probation go to a non-reporting status when you complete the terms. Good luck to you, sir.
Thank you, Judge.
Next is position 41, Mr. Sims.
What are we doing with Mr. Sims this morning?
Your Honor, that's gonna be a negotiated plea. The recommendation on there reflects the accurate jail sentence. It's a time served sentence, Judge, with other conditions.
Okay. Good morning, Mr. Sims. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir. You can place your hand down. Mr. Sirocco?
Thank you, Judge. On the 3 counts here, criminal trespass, possession and use of drug-related objects, and the tampering charge, respectively, the state's recommendation for count 1 is 12 months, served 34 days. Credit for time served 17 days. That is from September 7th of this year to present. Balance probated. Stay away from 514 Sunset Avenue, Northwest, Atlanta. 40 hours community service. Count 2 would be 12 months probation concurrent with count 1, ADET. And count 3 would be 12 months probation concurrent with count 1 as well, with an Op 21 law and decision-making course. We would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea.
Mr. Dodd?
We stipulate, Judge, we ask the court to follow the state's recommendation. I would ask the court consider non-report upon completion and waiving the first 2 months. Mr. Sims indicated the housing is not an issue for him.
And no objection to non-reporting once conditions are complete here.
Mr. Sims, it's my understanding that in case 25 CR 005362Y, you wish to plead guilty to criminal trespass, possession and use of drug-related objects, and tampering with evidence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Sims. I will have the probation go to a non-reporting status once you complete the terms. Good luck to you, sir.
Yes, sir. Thank you, sir.
Next, Judge, I have position number 19, Ms. Hawkins, and to answer whoever put that on, I do have position number 4. Arcier.
We're doing Ms. Hawkins first, is that right?
Yes, Judge, thank you.
Okay. So, Ms. Tucker, what are we doing with Ms. Hawkins this morning?
It'll be a negotiated plea, Your Honor.
Okay. Good morning, Ms. Hawkins. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am?
I'm sorry, Judge, she's.
Okay. Do you swear or affirm the testimony you're about to? You're fine, Ms. Hawkins. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, ma'am. Mr. Rhodes?
Yes, Your Honor, the state's recommendation on the sole count is 12 months to serve 30 days. The balance is on the balance will be on probation. We asked for a social work visit, and that Ms. Hawkins stay away from MARTA for a period of 180 days and have no further violent contact with the MARTA officer, in this case, Corporal Nicholas Shepard. All right, that's the state's recommendation.
And for just clarification, she was booked September 8th of this year and has 16 days credit.
Ms. Tucker?
We do so stipulate for the purpose of the plea, Your Honor, and we would request, well, there's, other than the, stay away from martyr, there's not really any terms, but we would ask that probation terminate or go on non-reporting status once she completes all the conditions.
Well, given that how do you want to handle this? The only condition is that she stay away from MARTA for 180 days.
I
Normally we
would
do, but
request that the balance be suspended, in this case.
Mr. Rhodes?
The state has no objection to the suspension of the balance, because we're just asking for a stay away. And then a social work visit, but
Right, yeah, we'll have a visit with a social worker before she leaves the jail. Okay?
thank
Is
you.
that agreeable with everyone?
Yes, Your
That is
Honor.
agreeable, Your Honor, because
Okay.
the suspended sentence still, in my opinion, still active, so.
Okay. So Ms. Hawkins, it's my understanding that in case 25 CR 005415Y, you was to plead guilty to simple battery against a police officer, is that right? Okay, you have to get a little closer for me, ma'am.
Yeah.
Okay, are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation? Say it one more time for me.
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right? One more time.
Yes, sir. Yes.
Has anyone forced you or coerced you to plead guilty?
Not that I know of.
Okay, I'll accept the plea as negotiated, Ms. Hawkins. Good luck to you, ma'am.
Thank you.
You're welcome.
Next is position 10, Mr. Brown.
Negotiated plea.
It is, Judge.
Okay. Good morning, Mr. Brown. If you'll raise your right hand for me, please, sir. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? One more time?
Yes, Your Honor.
Thank you. You can place your hand down. Yes, Mr. Rhodes.
The state recommendation is 12 months to serve 30 days. Balance probated. Obviously, he's entitled to whatever time he has served. 12-hour of anger management, 40 hours of community service, and no further contact with the victim, in this case, Travis Lankford, Lankford. And that's the state recommendation, Your Honor.
Mr. Dodd.
Or 12-hour, 12-day.
Your Honor, we stipulate for purposes of the plea, Judge. Mr. Brown is on very limited income, Judge. I would ask the court to consider waiving at least 2 months of his probation fees and perhaps non-report upon completion. He's been in custody since September 1st, Judge.
And so how much does that give him for time served?
23 days, Judge, credit for time served for 23 days. So essentially time served.
Yes. Mr. Brown, it's my understanding that in case 25 CR 005242E, you wish to plead guilty to terroristic threats and acts. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation? Say it again for me. You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Brown. I will waive 2 months of the probation fees to help you get on your feet. Once you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Judge.
Do you have, Mr. Murphy, do you have an announcement for the court?
Judge, I want to speak to state about position 4, Arcieri.
Okay.
All right, that's my case.
Um,
We can do a breakout room.
Yes, if you could. Thanks, Lamar. Be brief.
So could we go to some of if Mr. Sirocco has any additional cases, could we take his cases while we place Mr. Rhodes and Mr. Murphy into a breakout room?
Okay.
Yeah. Okay, thank you, Ms. Grace.
Yep, anything from positions 28 down, I think.
All right, we can go to position 28, Mr. Howard.
Also a negotiated plea.
It is, Judge.
Good morning, Mr. Howard. If I can get you to raise your right hand for me, please, sir. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down. Yes, Mr. Sirocco.
Thank you, Your Honor. For the willful obstruction, state's recommendation is 12 months served 28 days, credit for time served 19 days. Balance probated, that would come with an Op 21 law and decision-making course, and 30 hours community service as well. We would ask that he comply with any existing MARTA restrictions or suspensions. If there are such, I didn't see any from the report here, but we would ask that he comply with those as well. We asked defense stipulate the factual basis, venue, and identification for purposes of the plea. That is all for the state.
And Your Honor, we stipulate for purpose of plea, I'd ask for my usual waive the first 2 months of probation fees and consider non-reporting of completion of all the conditions, Judge.
And the
Okay.
state would not object to non-reporting upon completion of conditions.
Mr. Howard, it's my understanding that in case 25 CR 005312C, you wish to plead guilty to willful obstruction of law enforcement officers. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Sir.
You've been represented by counsel. Are you satisfied with his representation?
I know, sir.
Do you understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced you to plead guilty?
Sir, not at all.
I'll accept the plea as negotiated, Mr. Howard. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and have to pay those fees. Good luck to you, sir.
Thank you, Judge.
Your Honor, could you repeat the part about probation? How many months did you waive, or did you waive all?
There was no waiver.
Okay, thank you.
We can go to position 43, Mr. Sauter.
I believe that's Ms. Tucker, Judge. Ms. Tucker's case.
Okay. This is a negotiated plea as well.
It'll be a non-negotiated plea, Your Honor.
What is non-negotiated?
The time served requirement as well as the request for the stay away. When I spoke with him and his mother, Miss Cassandra, and she would like for him to come home, considering his medical conditions, and the state is ordering a stay away from their home address. We will also be requesting a reduction in the time served requirement.
Okay, Ms. Culpepper's on the line with us. I know that she's been with us a couple of times. I've been dealing with this case since the SCA calendar. Ms. Culpepper, would you like to address the court? Ms. Culpepper, are you with us? I know that she has been, I see her on the line. Maybe she stepped away.
I'm here. He went It wouldn't at first let me unmute it. I just got it unmute. But yes, I am
Okay.
here.
Yes, Ms. Culpepper, good to see you. Good to see you. Again, I'm doing just fine. And just to refresh my recollection, Curtis is your son, right?
Correct.
And you've been working with him regarding some of the issues that he's having,
Correct.
and you would like for him to, is he residing with you?
Yes, sir.
And you would like for him to continue to do so?
Yes, sir.
Okay. Mrs. Rocco, do you have any questions of Ms. Culpepper? I'm not sure if you've been with us when she's been here before and expressed her desire to help her son.
Right. I do have one. Miss Culpepper, I believe you had told the state that he would have somewhere else to stay. Was it with his grandmother?
He could go with my mother, but I would prefer my son at home because my mother, I wouldn't want to put him on my mother because she has to work at times too. And she has health conditions at too. But it's just, I said that because I would not see my son on the street with nobody. So that's the method of me saying that, but I do prefer him at home.
Okay. So, Your Honor, the state would be asking for, well, I'll give the state's recommendation and then provide some context if this is indeed non-negotiated. For the battery family violence, simple battery family violence case from September 5th of this year, that would be the most recent. Count one, the battery family violence would be 12 months served, 60 days, credit for time served, 18 days. That would be from September 6th of this year to present, balance probated, FIP, MHET, no further violent contact with Cassandra Culpepper. And we would ask for a stay away from the 1171 2nd Street Northwest address in Atlanta, as well as no firearms. Counts 2 and 3 would merge with count 1. The other open case that he has, which is 24, it's docketed at 24 CR 007809F, the 2 counts of simple assault, family violence. Both of those were against Miss Culpepper as well. We would be asking for 12 months probation concurrent with 25 CR 005364C, no further violent contact with Ms. Culpepper, stay away from that same address, and no firearms. And count 2 would merge with count 1. So with these 2 incidents, Judge, I'm getting some feedback. Is anyone else hearing that as well? Yeah. Okay. All right. I think I'm good now. Thank you, whoever fixed that. This incident took place, the September 5th one. Law enforcement responded to that incident location that the state mentioned, and they had spoke with, well, they observed that Miss Culpepper's lip was busted and bleeding. The defendant got upset over an issue with the noise with the music, wherein the defendant asked the Miss Culpepper's friends to turn down the music, resulting in a confrontation, and ultimately he punched her in the face when she asked him to go back in the house. In the 2024, the other incident dated from that's November 25th, 2024. He was charged with the 2 counts of simple assault, family violence for chasing her aggressively and swinging his fists at her. And let's see, I should mention as well, he was convicted in 2018 of battery, misdemeanor terroristic threats and acts. That was pled down from felony terroristic threats and acts, and disorderly conduct. And that was against the same victim, Miss Cassandra Culpepper, for striking her with a metal pole with his hands, leaving lacerations, bruising, and swelling, and threatening to kill her as well. The state's concern with this being 2 violent incidents in addition to that prior conviction against the same victim is out of concern for the victim. The no further violent contact, we understand that he needs help with medication. We also understand that he has a treatment team that visits him 3 times a week. But with this being incidents 2 and 3 with the same victim that we know of, we're concerned with the violence here, and we don't think they should be living together, despite what his needs may be with respect to MHET and whatnot. We know he has issues taking his medication, and we would hope that the treatment team that visits him 3 times a week would be able to ensure that he does take his medication. But the defendant should not be around Ms. Culpepper for Ms. Culpepper's safety, regardless of what the defendant's needs are, because something worse could happen. There is a risk of reoffense here, and we are extraordinarily concerned for her safety. And while we're fine with no further violent contact, we really, really stress that they should not be living together by any stretch. So that is the rationale behind the state's recommendation. And if Ms. Culpepper wants to say anything else, we would sound for her. But we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
I do want to state something.
And since you have your hand up there, Ms. Culpepper, do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I sure do.
Okay, you can place your hand down. Yes, what else would you like to tell the court, Ms. Culpepper?
I understand what he's saying, but like I stressed to you the first time, I'm not afraid of my child. I don't want the courts to be in fear of me, because this last incident, even though it was stated that he stretched me, if the police could have told you, I told him I didn't need them to take him to jail, because at the time of him doing it, like I said, and I'm not gonna keep making no excuses for him or not being on his medication, but I just want the court system to understand very well and hear me out clearly. I'm not afraid of my child. I do know how to defend myself if needed to with him, in which I shouldn't have to. But as far as his living situation, I prefer my child to be with me because I can handle him. And it's not stating that even though we don't have these incidents, all family households have issues, and all family, they have incidents. But my son is not a threat to me, and I want them to understand that very clearly. If anything, he's very overprotective of me, but he's not a threat to me at all, or a threat in my household. Only thing Curtis need to be understood of, and what I stressed y'all, and what his act team also stressed him, is to stay on his meds. So we will have this, so we won't, like I told you the last time, Mr. Morrow, so we won't have to come back. I'm pretty sure we will never have to come back, because I'm gonna have to sit, I have talked to my son, and we're gonna continue to talk with him to let him understand this. Before this incident happened, Curtis was in the process of the ACT team was helping him get him a job. He reports 2 times out of a week down at Grady, on Tuesdays and Thursday, that he report down there. We're in the process of trying to get Curtis his own home and get him stable to back, because he want to work. And they was also in the process of getting him a job. He needs to get, his problem is he been in the house, and Curtis gonna learn that he's ready to get a job, get himself back together, and get himself back where he's used to being. So he's already willing. When the ACT team, Mr. Jeremy, went down there and visit him this past Wednesday, he told Jeremy, his ACT team, that he's willing to go ahead and continue with his medication. He got an understanding that he needs the medication to keep from being too quick, or would cause him to cause a conflict. But he's very understanding of, now that's the place where he's at now, he don't want to be. So he's very understanding of that. And no, I'm not afraid of my child.
Okay. Thank you, Ms. Culpepper. As always, I appreciate you being here.
Yes, sir, Mr. Morrow.
And Your
Yes, Ms.
Honor,
Tucker.
part of the reason for the request for the time served requirement to be reduced, when he was on the calendar last week, it was a time served offer. And Your Honor, you asked for it to be reset so that he had time to meet with his medical team from Grady. Mr. Jeremy from the medical team did pay him a visit while there, and this new offer would require him to serve 12 additional days. So he'd already been in after receiving a time served offer for an additional week, and now they're asking for an additional 12 days. his demeanor. He's becoming more agitated while being there. I just don't believe it's the proper place for what he needs currently. So we are asking for a reduction in the time served requirement and as well as the stay away being waived.
And yeah, just briefly on that, that the offer made on that was for one case alone, and that would have been the 20, I don't have the case number in front of me, but the more recent case from September 5th of 2025. It was clear to me that that was not that his other existing open case, that we did not see that upon first reviewing and then ultimately making that offer on one case alone. So the state rescinded its offer. There was not a plea taken on that case that day, so that was not accepted. And that was so the state could provide a global offer considering not only his history, but also the fact that these are two violent cases against the same victim. So that would be the state's rationale behind that there.
Okay. And I do recall that I am the one that would not accept a plea last week because I thought that he needed some additional intervention from his treatment team, which apparently he has gotten. I don't believe it would benefit Mr. Suter or Ms. Culpepper for him to spend any additional time in jail. So I'm not gonna order that he spends any additional time in jail, but I will make additional requirements as far as him complying with his treatment team. So if nothing further, Mr. Suter, it's my understanding that in case 25 CR 005364C, you wish to plead guilty to battery family violence. And in case 24 CR 007809F, you wish to plead guilty to simple assault family violence. Is that correct, sir?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your plea, Mr. Suter. For the battery family violence, the court sentence will be 12 months to serve 36 days, credit for time served 18 days, the balance to be probated, a family violence intervention program, a mental health evaluation, and any treatment that's necessary. No further violent contact with your mother, Ms. Culpepper. No drugs, alcohol, weapons while on probation. You are also to remain compliant with all medications and recommendations from your treatment team, and you're to remain going to your treatment team while you're on probation. For the simple assault, will be 12 months concurrent with the previous sentence, no further violent contact with Ms. Culpepper, and no firearms. I am going to waive the probation fees while you're on probation, Mr. Suter, but I'm going to require that you remain on probation for the entire term. If nothing further, good luck to you, sir. Ms. Culpepper, good luck to you as well. I appreciate that you showing up and being here every time we've had court. Thank you, ma'am.
Thank you, Mr. Barber.
All
And
right.
just for the record, defense does stipulate for the purpose of the plea. I don't believe I stated that earlier. Thank you.
Thank you, Ms. Tucker.
Okay, who do we have next?
I have judge position number 31 through 32, Ms. Jones.
ACDC.
Okay, you're back. Okay, Mr. Murphy, I'll do your case next.
I just want you guys to call me. I need to speak to Miss Arcieri one more time when you get them all.
Okay, not a problem.
Thank you.
Let's see, Ms. Tucker, what are we doing with Ms. Jones today?
This will be a negotiated plea. However, I didn't previously discuss this with the state. She just requested if she could enter a NOLO on this plea.
Let me look into this really quick.
And while the state is doing that, just an announcement to the court. Add-on position 1, Ms. Mason is going to be a medical reset.
And what's the date of the reset? When are you requesting that? The Thursday? I mean, is it a time served, please?
I actually haven't received the offer from the state on this position. I did message asking for one.
Is this is one of the add-ons?
Yes.
Okay, the reason for that is we did receive this, like looking back, it looks like we got this around almost 3:17 yesterday, something like that. So a reset would be fine for this.
Okay, we
Okay.
can reset for Thursday, the 25th.
So we'll reset.
Your Honor, that might be our position on that calendar because we received it at 3:17 yesterday.
Okay.
That
And I know that I did place all of Ms. Shelton's cases on today's calendar so that I could review them. I believe that she was on the SEA calendar on Friday, and I wanted everyone to have an opportunity to take a look at that. So I take it that we really haven't had that opportunity. Mr. Dodd, would you be opposed to resetting Ms. Shelton until next Tuesday?
I'm sorry, Judge, I thought, I thought Ms. Tucker was talking about the add-on, Dejana Mason. Am I?
No, she was. I've moved on.
On Ms. Shelton, Judge, the social worker is speaking to her right now. We already talked to her, Judge. She wants to deal with her cases. Judge, I think, I mean, she wants to resolve the cases, but in light of the quantity of cases, I'd ask to reset it for the next week.
Okay, that was my recommendation, was to reset it for next Tuesday. That's agreeable with everyone.
Yes, Judge.
Okay, that fine with you, Mr. Rhodes?
That's fine with the state, Judge.
Okay, so you all have an opportunity to work up something on her.
On
right.
Denasia Jones, I don't see a NOLO within the past 5 years, but she does have a giving false info conviction from 2021. And one of these is a willful obstruction. We would seeking a guilty plea. That's what the state's recommendation was for here, and we would be asking for the same. The incident here with the theft of lost or mislaid property was from July 11th. That involved the defendant driving an Uber and the victim leaving an Apple iPhone 11 with a value of $800 in that, it was a Lyft. In that vehicle, ultimately they determined the identity of the driver to be the defendant here, and there was no efforts at returning the phone. So that's case 1 from July 11, 2025. And then the more recent case from September 5th, 2025 was the willful obstruction, where she had an outstanding warrant from Riverdale PD for failure to appear. The officer approached and made contact with her while she was in the driver's seat of her vehicle, and ordered her to exit the vehicle. She refused to comply. and had physically removed her from the car and placed her into detention. She refused at that point as well to place her hands behind her back, pulling her arms away from her body. So that would be the willful obstruction there. The state's recommendation would be on position 31, a guilty plea to the theft of lost or mislaid property, 12 months, served 36 days, credit for time served 18 days. That is from July 26th of 2025 to July 28th of 2025, and then from September 9th of 2025 to present, balance probated. Anti-theft course, $800 restitution to Ryan Beeley, B-E-L-E-Y. And on position 32, the willful obstruction, 12 months probation concurrent with 24 CR 004-265C, a $300 fine on that. We would ask defense stipulate the factual basis, venue, and ID for purposes of the plea.
And Ms. Tucker, I will allow her to plead no to the theft charge, but it would require her to plead guilty to the obstruction charges. That's what she chooses to do.
Yes, Your Honor. We can move forward with that, and we do so stipulate for the purpose of the plea. We would also like to request to the court for position 32, the willful obstruction, that the $300 fine be converted into 30 hours of community service. And that for both cases, once she completes the terms of the probation, that she be allowed to go on non-reporting.
State would be fine with non-reporting.
Ms. Jones, it's my understanding that in case 25 CR 004265C, you wish to plead guilty to theft of lost or mislaid property. You plead no to theft of lost or mislaid property. And in case 25 CR 005408C, you wish to plead guilty to willful obstruction of law enforcement officers. Is that correct? Yes, and I don't know if I swore you in, so if I could have you raise your right hand for me. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, I still can't hear you very well, ma'am. Can you scoot? Okay, yes, thank you, ma'am. You can place your hand down. And as to the questions that I asked you regarding pleading no and guilty, what was your response? Do you wish to plead no and guilty to those charges? Have to scooch up for me. We can't hear you. Okay. Are you under the influence of any drugs or alcohol at the present time? Say it again.
No.
You've been represented by counsel. Are you satisfied with her representation? Say it again.
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading no and guilty to them, you're giving up that right? Yes?
Yes.
Has anyone forced or coerced you to plead no and guilty? Say it again.
No.
I'll accept the no and the guilty plea. I will convert the fine to 30 hours of community service. And once you complete the terms, I'll have the probation go to a non-reporting status. Good luck to you, ma'am. She has a question, Ms. Tucker?
If the question is for me, I can give you a call.
No, it's for the.
Okay, you are speaking on the record in front of the prosecutor as well as the judge.
So for the probation, like the reporting, can it just be like Zoom call? Cause I don't have a way to get there. I lost my card.
If she needs to report by phone, I will allow her to report by phone if that's her request. All right. Good luck to you,
Thank you,
ma'am.
Your Honor.
Thank you.
Next, our positions 11 and 12, Mr. Brunson.
Your Honor, Ms. Jones, did you say non-reporting?
Yes.
Thank you.
All right. This is going to be a bond hearing.
Judge, maybe, just to back up, Judge, Mr. Brunson was on the calendar last week. We did a bond hearing. The court was not inclined on changing the bond. I had presented to the court that I was just informed that the victim had passed away. We reset it for today. I've got the death certificate. I forwarded it to the state last week, and I'm waiting to, I mean, it's 2018 case. He's got a Clayton County hold, Judge. I'm waiting. State will not prosecute.
Yeah, I do believe we received the
I know.
death certificate that you sent Mr. Haddad. As such, as it relates to position 11 and 12, the state will we'll send the paperwork over for null prize. And thank you for sending that, Mr. Haddad. My apologies for not getting with you earlier.
Thank you.
Okay. Where do we go next?
Judge, I have position number 4, and that's Mr. Murphy's case.
Yes, Mr. Murphy, what's the announcement?
Judge, that's going to be a plea this morning. I've spoken to Mr. ASG Rhodes, and that's going to be a negotiated plea.
Okay, very good. Good morning, Ms. Arcieri. If you'll raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, ma'am. You can put your hand down. Mr. Rhodes?
Yes, Your Honor, based on the negotiations with counsel, we have amended the offer to something acceptable to both parties, 12 months to serve 40 days. Credit for time served that she's been in, balance probated. We've asked for an anti-theft course and restitution in the amount of $390. And we ask that she stay away from the marshals at 5932 Roswell Road in Sandy Springs, Georgia. And that is a recommendation of the state, Your Honor.
Judge, she's been in custody 18 days, so I wanted that to reflect 18 days in custody, so she'd have 2 more to serve. And we'd ask probation to terminate as soon as she finished the restitution payment and the class. She is gainfully employed. She's a resident of Fulton County. She regretted a foolish incident, nothing more, nothing less. But again, we'd ask that you follow that recommendation. I've spoken to my client about the waiver of rights, and she's aware of the rights she's giving up, and she's authorizing me to sign an initial on the appropriate spaces on the plea forms therein.
Okay. Nothing further, Ms. Arcieri. It's my understanding that in case 25 CR 005351G, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
Absolutely not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and if by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Once you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, ma'am.
And I'll be released in 2 days, they said? You said 20 days to serve?
Mr. Murphy?
Yes, Judge, it was, we were asked, Mr. Rhodes and I stipulated to that she's got credit for 18 days served. So she should have 2 more.
Okay. Yes, ma'am. Good luck to you.
Thank you.
Your Honor, I know they changed the days. Did they change the community service hours, or is it still 100?
No, we've eliminated the community service.
Okay, thank you. I missed that part.
Restitution and the theft class, and that'll be it.
Thank you.
Next is position 15, Mr. Chancey.
And I have no low plea. Has that been agreed upon?
The state is perfectly fine with a no-law, Your Honor. Yes.
Okay. All right. Good morning, Mr. Chancey. If you could raise your right hand for me, please, sir. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Is that a yes or no question?
Yes.
Okay, thank you. Mr. Rhodes?
Yes, Your Honor. As it relates to this case, Your Honor, on the simple battery, which is count two, the state's offers 12 months served, 60 days balance probated, credit for times already served. He's entitled to stay away from the Origin Hotel at 110 Mitchell Street. Have no further contact with the victim in this case, Tracy McCowan. And we're asking for an alcohol drug evaluation and treatment and 12 days or weeks of anger management. And as it relates to count one, the disorderly conduct, we're asking for 12 months probation, credit for time served to run concurrent to count two. And as it relates to count three, public drunkenness, we're asking for 12 months probation, credit for time served to run concurrence with counts 1 and 2.
Mr. Dodd?
Your Honor, the couple of things on this case. First of all, we stipulate as far as factual basis, identity, and venue judge. On Mr. Chancey, he has custody since August 15th of this year, which is the date of the incident. This happened at the Origin Hotel. He was arrested, wasn't ACDC until he was brought to Fulton County on hold on, Judge, my brain went blank. Until he was brought to Fulton County Jail on the 6th, but he has been in custody since August 15th. So my calculations, he's completed 39 days in custody. So that means it's a time served sentence. He is from Dallas, Texas, Judge. He was visiting when this happened. I'm speaking to him. His version of what transpired is different than the state's case, which is why we requested a NOLO plea. He'll be going back to Dallas, Judge. So I was going to ask the court to allow him phone-in report. But he just lives there and works there, Judge. So once he's released, going back home.
Okay, anything further, Mr. Dodd?
No, Judge.
Mr. Chancey, it's my understanding that in case 25 CR 005356E, you wish to plead NOLO to simple battery, disorderly conduct, and public drunk. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and if by pleading NOLO to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead NOLO?
No.
I'll accept the NOLO plea. Mr. Chancey, I will allow you to report by phone. When you complete the terms of the probation, I will have it go to a non-reporting status. Good luck to you, sir.
Next, Judge, I have positions 6 through 9, Braswell.
Also a negotiated plea. Ms. Tucker.
Yes, Your Honor.
Okay. Yes, good morning, Ms. Braswell. If you could raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you, ma'am. Mr. Rhodes?
Yes, Your Honor. As it relates to position number 624 CR 007212B, simple battery family violence, the state's recommendation to the court is 12 months to serve 30 days, credit for time served, balance probated. We'd ask that Ms. Braswell complete the 24-week FVIP and to have no further violent contact with Mr. Braswell. We also ask that alcohol drug evaluation and treatment be applied to this case as well. Your Honor, as it relates to position number 9, which is simple battery family violence, the state's recommendation is the same. It involves the same individuals in this case, 12 months to serve 30 days, credit for time served, balance probated, the 24-week family violence intervention program, along with alcohol drug evaluation and treatment, and no further violent contact with Mr. Braswell. Your Honor, we ask that position number 9, 20 CR 00323 8B run concurrent with 24 CR 007-212B. And as it relates to position 7 and position 8, the state will enter null pros upon the acceptance of this plea.
Okay.
Thank you, Your Honor.
And Your Honor, for the record, she has been jailed since August 25th of 2025. So she has been incarcerated for 30 days now, for the credit for time served. But we do so stipulate for the purpose of the plea, Your Honor. And we will request after completing FFIP that she be allowed to go on reporting status.
Okay, Ms. Braswell, it's my understanding that in case 24 CR 007212B, you wish to plead guilty to simple battery family violence, and in case 20 CR 003238B, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
So I will be entering Fulton County Drug Court after this. For 18 months, I'm gonna stay inpatient.
But as for today, you're not under the influence of any drugs or alcohol. Is that correct?
No, sir, I've been locked up since February 28th of this year.
Okay, so my question requires a yes or no answer, Ms. Braswell.
No, I'm not on it.
Okay, so you've been represented by counsel. Are you satisfied with her representation? You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, Your Honor.
Has anyone forced you or coerced you to plead guilty?
No, Your Honor.
Okay, I'll accept the plea as negotiated, Ms. Braswell. When you complete the terms, I'll have it go to a non-reporting status. Good luck to you, ma'am.
What is the terms of 24? What 24?
Was 12 months to serve, 30 days, credit for time served, balance probated, a family violence intervention program, no further violent contact with Mr. Braswell, and an alcohol drug evaluation and any treatment that's necessary. Okay?
That'll go on with the drug court, right? I can do all that in the drug court, Fulton County drug.
Ms. Tucker, can you talk to her about that after court today?
Yes, I can give you a call, Ms. Braswell.
All right, thank you.
Thank you. Good luck to you, ma'am.
All right, thank you.
Next is position 48, Mr. Williams.
This is going to be a negotiated plea as well.
Yes, Your Honor.
Yes, good morning, Mr. Williams. If you can raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, sir. Mr. Sirocco?
Thank you, Your Honor. For the criminal trespass, the state's recommendation here is 12 months served 28 days, credit for time served 14 days. That is from September 10th of this year to present. Balance probated, BHET, 20 hours community service, and stay away from the 300 Prior Street, Southwest Atlanta incident location. We ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
We do so stipulate for the purpose of the plea, Your Honor, and we will request that after completing community service, that probation be allowed to terminate or go non-reporting.
No objection to non-reporting, Judge.
Okay, Mr. Williams, it's my understanding that in case 25 CR 005466B, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
I do, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Williams. When you complete the terms, it'll go to a non-reporting status. Good luck to you, sir.
Thank you.
Next, Judge, I have position number 36, Mora.
What are we doing with
This
position
would be a
36
negotiated
today?
plea, Your Honor.
Good morning, Ms. Moore. If you could raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Say it again for me. Okay, thank you. Mr. Sirocco?
Thank you, Your Honor. For the 2 counts of theft by shoplifting, count 1, the state's recommendation is 12 months, served 60 days. Credit for time served 26 days. That is from August 29th of this year to present. Balance probated, 40 hours community service, anti-theft course, and a $500 fine, given her history here. And on count 2, 12 months probation concurrent with count 1, stay away from TJ Maxx at 1 Buckhead Loop, Northeast Atlanta. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. That is all for the state.
Tucker?
We do so stipulate for the purpose of the plea. In Your Honor, we will request that the first 3 months of probation fees be waived so that she has the opportunity to make payments on that fine. And once she completes the terms, that she be allowed to go on non-reporting status.
Which the state would be fine with.
Okay. Ms. Moore, it's my understanding that in case 25 CR 005184A, you wish to plead guilty to 2 counts of theft by shoplifting. Is that correct? You're gonna have to scooch up a bit. Okay. Are you under the influence of any drugs or alcohol this morning?
No, sir, I'm not.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, ma'am. I'll waive the first 2 months of probation fees to help you get on your feet. Once you complete the terms of the probation, it will go to a non-reporting status. Good luck to you, ma'am.
Thank you.
You're welcome.
Next, Judge, I have position number 40,
Okay.
short loaner.
Yes, what are we doing with Ms. Shartloader today?
It'll be a non-negotiated plea, Your Honor. We're requesting a reduction in the time served requirement. She has multiple mental health diagnosis. Excuse me. So we're requesting that she be allowed to have a time served offer. She is willing to do more conditions on her probation in exchange for that. She said she's willing to do additional community service hours for a time served offer.
So the state's recommendation is going to remain as set, and I'll go into that when the court's ready.
Ms. Washington, may I have the history, please?
Yes, Your Honor, what is the defendant's first and last name or position number?
Position 40.
There are 2 arrest cycles here in Georgia, which include these cases. And also, there appears to be an arrest from 2022 for assault and battery out of Virginia that was dismissed. There also appears to be history out of Florida, including 1 arrest, and it was regarding a theft case. No disposition is listed there. There are also arrests out of Maryland And those arrests do not include a violent history. However, there was one arrest for arson and no disposition was listed, and that was from 2021.
I do have for that one that at least for the arson slash threat is what the charge was labeled as. I have probation before judgment. How that works in Maryland, I'm not sure, but there was a destructive device charge that was null prost after she completed a pretrial diversion. I do see in Georgia, what I have is 3 arrest cycles, including the present, because it looks like there's an open case out of DeKalb for criminal trespass and simple assault from this year. And then she was just convicted in May of this year that was criminal trespass and simple battery against a law enforcement officer, as well as simple assault. And that's under 25 CR 002175D. That incident that took place in April of this year at the Grenada Hotel in Midtown. Which I'll get into. It's like our case here, also a hotel incident. And that was for throwing glass at a hotel employee, striking him with it, and spitting in an officer's face, as well as damaging a hotel heater. For that, she was sentenced to serve 26 days with 12 weeks anger management, MHET, and 20 hours community service. So the state's recommendation here, which is 12 months served 60 days, credit for time served 18, that is from September 6th of this year to present, balance probated, 12 weeks anger management, no further contact with Christian Wright, and count 2, the theft of services, would be the 12 months probation concurrent with count 1 anti-theft course, stay away from the Belliard Hotel at 1 Interlock Avenue, Northwest Atlanta, and 40 hours community service. So essentially what we've done is we have given that prior conviction with the 26 days and given her history. We have increased the time that she would serve respectively. And we've also increased the community service hours. Those went up marginally from what she was sentenced to in just May of this year for similar offenses, because here this involved this was September 6, 2025. Officers responded to that Belliard Hotel location and met with the hotel concierge, who explained that the defendant, she had attempted to book a room, but her credit card was declined on payment attempts. She remained in the lobby area overnight due to being unable to book a room. She began to get boisterous and started cursing over some items she claimed were missing, calling the officer stupid and ignorant. When Mr. Wright, the hotel concierge, approached and asked that she be removed due to her unruly behavior, defendant began to yell, curse more, and then threw a handbag at him, striking him. So not dissimilar to the case of which she was just convicted. And also the defendant had a tab from the bar for beverages and food, roughly $60 that she had tried to send her to another room that she wasn't registered to. And she provided a card. That card was declined. She had no means to pay that balance. So the state's recommendation is what it is based on her history, prior sentencing, and we feel it's more than appropriate in this situation. We would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea, and if we could sound for Mr. Christian Wright.
The Wright is on the line and wishes to address the court. Now is your opportunity. Ms. Tucker?
We do so stipulate for the purpose of the plea, Your Honor.
Anything further?
Yes. Well,
If
I don't
there's
know
nothing further, I'm going to make a determination on the jail time. So if you want to tell me something else about that before I make that determination, I'm happy to listen to you.
I don't want to disclose her medical conditions because we're streaming. So there's nothing further, Your Honor.
Given the history, I'm going to require that I'm going to accept the state's recommendation if that's what she wants to proceed with. You need to speak with her, Ms. Tucker.
She is willing to proceed, based on previous conversation.
Okay. Ms. Schott-Lutner, it's my understanding that in case 25 CR 005360D, you wish to plead guilty to simple battery and theft of service. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, I am not.
You've been represented by counsel. Are you satisfied with her representation? I'm sorry, I can't hear your answer.
If I say no, what does that mean?
Well, it sounds to me that you're not happy with the representation, so we'd have to
I
get you.
I will take the plea. I will take the plea.
That is not my question, though. My question is, are you satisfied with the service that Ms. Tucker has provided you? If you're not satisfied, we'll get you another attorney, ma'am.
I want to sober because I have PTSD, Your Honor. I'm breathe because I'm having
Okay,
a panic.
I'm gonna. Okay, all right. We're gonna take a minute.
Okay.
So
So
let's
just give me
take
a
a
moment.
moment. Yes, take your time, ma'am. While I'm waiting, Mr. Dodd, are you with me?
I'm here, Judge.
29 and 30, Mr. Johnson, what are we doing with him today?
Your Honor, that is a waiver.
Okay. And if you don't have any other clients this morning, I see that we have Mr. Presley on the line for the DV calendar, I believe. Would you mind speaking with him?
Not at all. If Mr. Presley can put his phone number in the chat line, I'll give him a call.
Morning, Mr. Presley. If you'll go ahead and do that for me. This is Mr. Dodd. He's a public defender, and he'll represent you this morning, okay?
Okay.
All right, so
Judge, when you get a chance, if you can go ahead and repeat the terms to her again.
okay. Repeat the last question. Is that, or repeat the terms of what's going to be required? Okay.
Thank you.
12 months to serve 60 days, credit for time served 18 days, balance probated, 12 weeks of anger management, no further contact with Christian Wright, and that is for the simple battery. For the theft of service, it will be concurrent with the simple battery, an anti-theft class, stay away from that hotel, and 40 hours of community service.
What does balance probated mean?
That you're going to be on probation until you complete the terms of this sentence. So,
Days, does that mean I remain in jail?
you won't remain in jail. They're asking for 60 days. You're going to get credit for 18 days. The jail
You have
gives
12 days to serve, as we discussed yesterday.
Okay.
I understand.
And what would you like to do, ma'am?
Well, I'd like to take the plea.
Okay. And my last question to you was if you were satisfied with the service of Miss Tucker.
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, I am not.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
I do.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I will accept your plea, ma'am, and the court sentence is going to be that recommendation of the state. Good luck to you, ma'am.
Your Honor. Thank you, Judge.
You were.
Your
Oh,
Honor.
and just let me say, it'll go to a non-reporting status
Oh,
once you
thank you.
complete the terms.
Thank
So
you.
once you're done, it'll go to non-reporting, so you won't have to report, ma'am. Okay,
Thank you, Your Honor.
we have next. Is AC/DC coming back or? Is that it?
I believe that may be all the cases from ACDC.
Okay. Mr. Mr. Dodd, what are we doing with positions 2 and 3?
He was,
That's what the announcement said.
Your Honor, I may have messed up. Mr. Allen I saw him yesterday and he was gonna take a plea, Judge, but I think when I filled out the paperwork, I mean, last night they sent the email, I may have inadvertently said he's released. Hold on. I apologize, Judge, just 1 second. No, Your Honor, it's supposed to be a plea, Judge. They'll, yeah. They're gonna go get him, Judge.
Okay. So while we're doing that, are we able, I believe that will complete the calendar for the 9 o'clock calendar. Do we want to handle Mr. Presley while we're waiting?
Yeah, that'll be fine, Judge. I'm ready. I'll be heard when the court
Okay.
allows me.
Mr. Sirocco, I take it that Mr. Presley missed a court date.
Yes, Your Honor. Can you hear me all right? I had to switch to
Yes.
headphones here. Okay. He failed to appear on September 11th of this year for plea and arraignment. That was before Judge Edie. There is no return to sender notice on file, and the address they appeared to have at the time is the same as it is now. Yep, that is what the
Okay.
state has with respect to the FTA itself, but we do have more information here.
Mr. Dodd?
Judge, on behalf of Mr. Presley, the alleged victim was then his wife. And so when he was arrested, that was his address. He had to move out, of course, because he had to stay away. And I think there might have been a temporary protective order along the lines through the marriage. They have since divorced. So when he received the notice, he was not living there. They've since divorced, and he actually got the home as part of the divorce. So he's living at that home, the same address. His now ex-wife moved away, Judge. So he's back at that residence, and he can get notice. This is his first time, Judge. I don't believe he's got much of a history, if at all. And I would just ask the court to set aside the bench warrant, Judge.
So what I will say is I do have on the bond, the original bond, it was only no further violent contact and to enroll in DVIP. There was no stay away ordered. I will say also that while this date was September 11th of this year, the FTA, just a day before that, the victim had reached out to us because the defendant had been harassing her. And actually, she says he lit one of her car tires and also keyed her car. She sent us photographs of the vehicle. And she states he's been making her life and her children's lives a quote unquote living hell. He will say a number of disrespectful things to her. We have dozens of text messages of him doing that. So he is really, really skirting the line of what nonviolent contact is. She states, oh, excuse me, she states that he actually sexually assaulted her since the bond was given here with no violent contact, and that he would continue to stalk and torment her at her friends' residences, and she basically had to change her whole life. It's my understanding she has moved since then, and she certainly no longer resides at the address. And she is more than interested in seeing through the prosecution of this case. So I will state that on her behalf. So for those reasons, in addition to there being no substantiation as to the defendant missing his court appearance, the state would be objecting to the lifting of the FTA here. And we will be looking into a bond modification pending more details from the victim here.
Okay, well, all I'm here for today is this possible set aside of missing a court date. All of that other, you need to go through the correct process. And I take it that she's not with us today. And if Miss Eugenia Presley is with us, I'm going to give you the opportunity to speak today. I still haven't heard why he missed the court date. If he's living at that 133 Trinity Avenue address and the notice was sent to that address, what's the issue?
The issue is that when the notice was sent, he was not living there. And this is information coming from Shocking an ex-wife who I wouldn't be surprised if passed the notice. So as far as our contention, Mr. Preston did not get the notice. He has, since the parties have divorced, he's gone back the custody of, I shouldn't say custody, his property back, and that's where he's living, Judge.
When did he start living there?
Mr. Presley?
Yes. So basically, I ended up moving back into the house around about August 20th. I initially filed a TPO against my ex-wife at the time on June 20th. When she found out, got word that I basically filed a TPO, she did a counterclaim on that TPO and stated all of those false accusations. We then had court on August 11th. I have that case number if you want to. That judge awarded me the house, extended the TPO for another 30 days, where I had one and she had one as well, and gave her a deadline when to move out of the home. So at that point in time, I wasn't at the home because I basically stayed away from the home because I didn't want to put my bond in jeopardy at that point in time. So during that time, the mail came in, but she still had full access to the home in the mailbox. So I never ended up getting the actual notification of the court date on September 11th. The way I was advised of the court case that I had missed it was from my pretrial officer, who he wasn't even necessarily advised until he saw that I had missed court. At that point in time, September 12th, I came down to the courthouse. I ended up doing a rescheduled hearing for today. And then a couple of days later, we initially tried to do a motion for the bench warrant for failure to appear. But then I later went back that following Monday, and just to find out I had to do an e-file on that. So just to answer your question, I wasn't living at the home because we had an actual 30-day stay away order from each other that gave her time to basically move out of the home.
Okay.
I don't have if there's such a stay away order, I don't have the date of that, but I do have that from when we spoke to her on July 23rd. She stated that they were living together.
No, we weren't. And I moved out initially July 20th. I can give you the case number if you need to, but that counterclaim that you're referencing was in retaliation of me putting the TPO order out on her. The judge, we had a hearing on August 11th that extended it. So that statement that she said, we've already been to court in regards to all of those allegations that she stated, and those were false.
Okay, so we're only dealing with the missed court dates. You've given me a reasonable explanation. Mr. Presley, it's my practice that I will set aside a bench warrant on one occasion. You need to stay in touch with the court to make sure that you do not miss another court date.
Yes, sir.
It's my understanding that you are now receiving, or that you're living at the Trinity Avenue address, so
No, sir.
you're not
It's
living there?
No, that's the incident. That's where the incident took place, where she was committing adultery. The
Okay,
arrest location.
I don't need to hear all that. Just tell me
I'm
where
sorry.
where you want to get your notice.
The 7880 Blue Sparrow Drive, Fairburn, Georgia 30213.
Miss Young, is that what we have in the system?
I'm gonna now, Your Honor. Hold on one second. I want to say that's what I saw yesterday. Uh, 7880 Blue Sparrow.
Okay, so that's where you'll be getting your notice. If you miss court again, Mr. Presley, the bench warrant won't be set aside the next time, okay?
Yes, sir. Yes, sir.
All right, good luck to you, sir.
Yes, sir. Thank you.
You're welcome. And is this Mr. Allen that's in the court with us now?
Right.
And this will be a negotiated plea?
Yes, Judge.
All right, good morning, Mr. Allen. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
No.
Okay, you can place your hand down. Thank you, sir. You still with me, Mr. Rhodes?
Is this a negotiated or non-negotiated plea?
It's a negotiated plea.
Okay, let me pull up the state's recommendation here. This was for position 4.
Position number 2.
Number 2. Oh, I don't see. Oh, Mr. Rhodes, Deputy Rhodes may have the recommendation for that. I don't see it on the sheet here.
I think it's at least on the calendar that was sent to us. It was on
2, yes.
Oh, it looks like, okay, it's in the charge section. Let's
Yeah,
see.
I put it in the charge section. The recommendation on that is 12 months to serve 30 days, credit for time served, balance probated, 12-hour week anger management, no further contact with the victim. And the victim is Miss Zamana Singleton, and that's spelled Xiomana Singleton, the traditional way, and also a Dominique Gordon, but Dominique DA instead of DO. And then also stay away from 2845 East Hampton Court in South Fulton, Georgia, 30349. So it relates to count 2, Your Honor, the disorderly conduct. We ask that the 12 months probation run concurrent, credit for time served, and that alcohol drug evaluation and treatment be applied to that particular count. That's the state recommendation in position number 2. And we will null pros position number 3 upon plea.
Mr. Dodd?
Your Honor, on behalf of Mr. Allen, we do stipulate for purposes of the plea, the incident date, April 20th of 2023. I could not find any arrests information for that. He did have a failure to appear. He was arrested in Fulton County on March 11th and bonded out March 18th. So that's a total of 7 days that he's done. And then he was rearrested again on a failure to appear, and he's been in custody now for 8 days. So he has a total of 15 days broken up. So essentially, it's a time served sentence, Judge.
Further?
Nothing further, Judge. And I
Okay.
ask the court consider non-report upon completion of the conditions.
Okay, Mr. Allen, it's my understanding that in case 23 CR 006467E, you wish to plead guilty to simple battery and disorderly conduct. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Once you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Judge. Thank you.
You're welcome. Let's see, Ms. Young, I believe that completes the calendars whenever you're ready for us.
Position 1 was released. Position 2 and 3 were a plea. Position 4, plea. Question on position 4, who are they paying the restitution to? They said stay away from Marshall's, but it didn't give who she needs to pay the $392.
I don't have a name, but I'll get a name, right? It's just Marshall's at the address that I provided, but I can get a name for you.
Thank you. Position 5 was non-profit. Position 6, plea. Position 7 and 8, non-profit. Position 9, plea. Position 10, plea. Position 11 and 12, non-profit. Position 13 was a plea. Position 14 was a plea. 15 was a no-low plea. 16 reset to 9:30. 17, 9:30. 18, 9:30. 19 was a plea. 20 reset to 10:7. 21 reset to 10:7. 22, 10:7. 23, jail jury, they waived. 24, plea. 25, 26, non-pos. 27, plea. 28, plea. 29, Derek Johnson. We had him down as that was gonna be 29 and 30. We still have to do those.
I think I'd make the announcement. It's gonna be a waiver.
Oh, it's gonna be a waiver. Thank you. I thought it was gonna be a plea. Okay, thank you.
Thank you.
Position 31 was a no-low plea. 32 was a guilty plea. 33, 34 reset to 9:25. 35 is a waiver. 36 was a plea. 37 was transferred. Along with, are you transferring 38 with the FTA?
Excuse me, position 30, this is Antonio Nelson.
Uh-huh.
Yeah, we would be seeking to transfer both. We have not received acceptance on this case yet. We would ask that it be reset at 1 week so we
1
can hear
week?
back from the DAs. Thank you.
Okay. 1 week. I thought it transferred, but I don't know who it was.
That was for position
It was right, wasn't
position that was Andrew Whitlow, position 47.
Okay,
That one was
thank you.
accepted.
it? Okay, so 1 week reset. 39, 10-7. 40 was a non-negotiated plea. 41 was a plea. 42 was a plea. 43 non-negotiated plea. 44 waiver. 45 plea. 46 plea. 47 was transferred. 48 was a plea. Add-on calendar. Position 1 reset 9:25. Position 2 waiver. Position 3 through 18 reset to 9:30. And then the DD calendar bench warrant set aside, reset further notice. That completes the call of the calendar, Your Honor.
Thank you, Ms. Young. Anything further from anyone this morning?
Yes, actually, Your Honor. I just received a call from ACDC from position 40. She was essentially stating that she was not satisfied with my service. Um, so I don't know if we should withdraw the plea and have her speak with the conflict attorney next week. It's not a term served offer, and I don't want to deny her what she feels is effective counsel.
Okay, Ms. Young, can we reset that for next week, Tuesday, and sign Ms. McLeod or Mr. Murphy to that case for me, please?
Yes, Your Honor.
All right, thank you, Ms. Tucker.
Thank you, Your
Anything? You're welcome. Anything further from anyone? All right, if
And
not, go
if
ahead.
it's, Judge, if it's of note, I apologize, I was making notes in a different case. The loss prevention officer's name for position 3, it was position 4, is named Kyle Paris.
KYLE.
Kyle Paris, Parris.
RRIS. Okay.
And Ms. Young, I guess it'll be in his care, but it'll still ultimately be the marshals. But in his care.
Okay. Well,
And
they paid for probation, so I just want.
Oh, okay.
to contact.
Okay. And do you have the amount? You do have the amount, right?
390.
Okay, thank you so much.
You're welcome. Please remember to send me all y'all paperwork in the NAW process so I can send them over to the judge.
This was for
They're
the
on their
theft by shoplifting case, right? That I was,
Correct.
okay, okay. Just
yeah.
wanted to check. Thank
Okay.
you.
Thank you.
Okay, anything else? If not, have a good rest of your day. We'll see you next week.
Have a good day.
You too, Your Honor.
Have a good
Thank
day.
you.
Thank you.